Good morning, everyone. Thank you for joining us. I'm going to address the topic of U.S. enforcement with a particular focus on what we're all reading now in the financial and FCPA press, that financial institutions may be the new thing, the hot topic, the new target for SEC and DOJ enforcement. And one of the things that we were analyzing and looking at Mayor Brown, is that a real proposition, or is that hype? What is the nature of the risk faced by financial services industry, and has it increased? So we looked at a number of things. First, we looked at historically. The financial services sector is number 7 in the number of enforcement actions that have been brought under the FCPA, well behind the extractive industry, the mining and the like, which is number 1. But if you look at the data, it shows that the percentage of new cases in the financial services industry is higher than in other areas. In other words, there's an uptick in activity. Not a dramatic change, but it's sufficient to make us think that things are turning in that direction. The next thing we looked at is what is the perspective of senior officials at the Department of Justice, the SEC, and the SFO, and elsewhere. And the reality is that the financial services industry is the apple of the enforcement sector's eye. The SEC in particular sees the financial services industry players as the superstars. They're the rock stars in their world, and they're always interested in what they're doing. And if you take as an example of that, you could look at the sovereign wealth fund cases, which was a sweep case. It was an elective case. And what was significant about it was not that it was particularly productive, because it didn't turn out to be that way, but it reflected an attitude on the part of the SEC to be interested and reach out in the financial services industry. And if you look at the quotes, the SEC leadership has made statements such as, we're looking at non-traditional industries with government touch points, such as private equity, and you wouldn't have to look too hard to find similar statements in the Department of Justice and the SFO. So there is an interest, there is an effort, and there is a focus on financial services. And the other things you look at is what's happening generally that's not focused on financial services but will affect them. And one of the issues is the increased global resources and interest in anti-corruption. When you analyze what the Department of Justice and the SEC is going to do, you don't necessarily look so much at the press releases as to what they're saying. You look at the budgets. You look at where the money is. And there's a tremendous increase in resources for FCPA corruption enforcement in both the SEC and the DOJ. And that money, we know, if we know one thing about enforcement efforts, that money will be spent and they will look for a return on that investment. Another factor that I think suggests that there is something that's going to be happening with financial institutions is the age of the empowered whistleblowers. The effect and role of whistleblowers is first beginning to take up some momentum, so cases in the financial services industry and elsewhere will uptick. And finally, you look at the new big mega cases and investigations. You look at FIFA. You look at Petrobras. In the FIFA area, the indictment names 26 banks. And while the banks are not targeted in the investigations, they're just named at this point, when you look at the DOJ press release, they announced that the investigation will look at the conduct of financial institutions to see whether they were cognizant of the fact that they were helping launder these bribes. So as a consequence of the additional resources in mega cases, the movement of money with respect to these bribery cases is receiving special and separate attention by enforcement, and the numbers are very large. And what we're seeing is a number of financial institutions now are reviewing their FIFA-related transactions to check their compliance practices. And another, issue that may also surface is Petrobras. Now, there is no U.S. activity at this point, but if you read the press reports, there are billions of dollars that went through financial institutions associated with that case. So what's the bottom line? Is it hype or is it real that financial services has additional exposure? We think it's real. If you look at the next slide, we look at certain basic legal principles and points, and this is not a seminar on the technicalities of the FCPA, but if you would highlight what you really want to think about when you're analyzing your exposure, it would be two things: knowledge and participation. You know, I'll give you an example. We're very often asked questions by our financial services clients, should we have someone join the board of the new entity that's involved? The question is sometimes, Larry, if this guy was a friend of yours, would you get on the board? And with enterprises and anything else, the issue of the board participation would be what is the knowledge and participation that this board position is going to create for that individual, and therefore what risk is involved. And that's a fundamental concept. It's not how much you invest, and there's nothing wrong necessarily in making a good faith investment that turns out to involve corrupt activity if you didn't know about it. But the fundamental question will be, what did you know? Were you, in the words of the DOJ press release, cognizant of the payment, and what was your role in participating in it? And the next to last bullet makes the point that with respect to due diligence, you can't bury your head in the sand. So these are core issues that we're looking at in assessing the exposure. And the one case that's a landmark in that regard was this Kazeni case, which involved Frederick Bork, the co-founder of Dooney and Bork. And what stands out about the case is that rather than prove Bork's actual knowledge of bribery, the government proceeded on a theory of conscious avoidance in order to impute knowledge to Bork. That is, in the financial services industry, it's all about, as in other cases, what is the knowledge of the players involved. And in that case, they found that Bork's awareness of pervasive corruption in the country, that he knew that his partner was known as the Pirate of Prague, and also certain tape recordings created a basis for establishing liability, even if there wasn't actual knowledge. And what did the tape recordings show? They showed Bork saying things like, what happens if they break the law? Let's say they bribe somebody and we hear about that at dinner. Well, you know, we paid these guys $10 million to get this. I did an endorsement. What do you do with that? Or just a statement that he made in general, do you think business is done in arm's length in that part of the world? So that is the knowledge and participation. So what do you do about this? What is the assessment? And the reality is that there's no one-size-fits-all compliance program or one-size-fits-all risk profile for folks in the financial services industry. It varies dramatically from company to company. One of the main issues is whether or not you're listed with the Securities and Exchange Commission. And what companies are doing now is they're doing these risk assessments to take account of the increased risk environment. And if you look at what a risk assessment looks at, it's set out at the top of slide 6. There are two things. First, we want to know how the company goes to business. And the only way to make that assessment is to sit down with an FCPA anti-corruption advisor and talk about your business, because it's not going to be on the organization chart. You know, what is the role of the senior executives in the United States in the foreign operations? What do they know about? What's the paper trail? How do they make their decisions? And in some instances, there's decentralization, no knowledge in the U.S., it's hands-off, and the risk is lower. In others, there are active, informed managers in the United States who know everything. And unless you know that about how the company goes to business, you don't know the risk profile. And the other thing is the government touch points. There are two places that you interact with the government. One is as a regulator, and the other is as a customer. And what companies do is they take those touch points, they put them on a sheet, they look at them, they see what controls they have with respect to each item, and they talk about enhancing them. So if something happens, which it always can, they can go to the government and say, listen, we did our risk assessment, we prepared, and if you like, you can have a look at it. Examples of risks. PAP clients are an increasing risk area. I think that's part of what the Petrobras is going to show, and to a certain degree, a lesser degree, FIFA, because they're not really government officials per se. But you want to look at those government customers who have custodian accounts at the bank, both individuals and SOEs. You want to look at raising funds from government sources, such as the sovereign wealth funds, and any of your marketing activities aimed at receiving funds from government entities. And finally, the last point that we wanted to address is you've done your risk assessment, you've looked at it, what do you do next? And we have what we refer to as the phone call. You're sitting there on Friday afternoon, you're minding your own business, everything's fine, you're ready to go for the weekend, and somebody calls you up and says, well, we have a problem in Borneo. Some guy did something or something happened. And what we recommend and advise is that you have a contingency plan that's ready to go when you get that phone call, so you know exactly what to do and how to handle it. And what we've suggested on slide 7 is a basic plan that we have as to exactly what you do when that happens, and we'd be happy to meet with any of you and discuss it with you.
So at this time, we're going to turn the presentation over to Alistair Graham.
Thanks, Larry. That's a very topical point to be talking about, because you asked the question whether this is hype or not. And if you asked the chairman of Barclays Bank as he was eating his cornflakes this morning whether it's real or hype, I think he would have responded that it's real, because on the front page of the Financial Times is a discussion about whether the SFO is inviting Barclays to talk about settling the Qatari deal probe. That is a criminal probe that's been running for some years. And it relates straight back to what Larry was talking about, raising funds from sovereigns. But before we get into that, perhaps it's worth just taking a look at the Serious Fraud Office, which is the entity in the UK which deals with anti-corruption. And it's not obviously as well developed as the SEC DOJ, and its leader, David Green, has been saying recently in a press campaign that it has recovered its mojo. I needed to have it explained to me, but mojo is basically he's saying we're back, we're effective, we're able to do this, because the SFO had a terrible reputation some years ago. He might be saying that because it's true. He might be saying it because, one, the Home Secretary, Theresa May, wants to abolish the SFO and turn it into the National Crime Agency, which is more of an FBI-type entity. He might be saying it because his 4-year term expires April 16, and recently, incidentally, the financial regulator, the FCA, Martin Wheatley, chief, did not get his term extended. And he might be saying it because a couple of days ago we had the annual report from the SFO, and their budget is to be cut for the next year by 34%. So he's talking a great game. Is he delivering a great game? Well, many of you will have heard of the 2010 Bribery Act, which was foreshadowed as a new frontier, new exciting, effective enforcement. And there has been a conviction for corporate foreign bribery, which is the Smith and Usman case. But it wasn't really a blockbuster. It was a small printing company and a relatively small bribe. But people did go to prison. The CEO went to prison for 2 years. Similarly, there has been a conviction of individuals under the new Bribery Act. That's the Sustainable Growth Group case. But again, that was primarily a fraud case. But if you look on the other side, I think there's a real question to be asked, because all the hype that was accompanied the 2010 Bribery Act coming in related to the Section 7 corporate offence. And you probably remember that that is any company carrying on business in the UK, and pausing there, not necessarily English companies, any company carrying on business in the UK commits an offence under Section 7 of failure to prevent a bribe if an employee, subsidiary, agent or service provider, note the wide definition of associated persons, bribes another person anywhere in the world to obtain or retain business. Now, there is a defence of adequate procedure, but this is the first time we've had strict liability criminal offence in the UK, and everyone, understandably, was very excited about it. Now, you shouldn't have held your breath, because there have been no prosecutions whatsoever under Section 7, and when I asked the director what the timetable was, they were still being under consideration. Now, that's the first problem. The second is that some of the prosecutions have gone badly wrong. The SFO tried to prosecute Celtic Energy and indeed its lawyers. It failed, and after it failed, it used a very rarely used mechanism to repeat the prosecution, and it failed again, and the judge said it's doomed to failure. But maybe I'm being a little harsh, because, of course, the FCPA took about 15 or 20 years to really get going in the US, and so maybe it'll take a bit longer for it to get going in the UK. Finally, on the first slide, I mentioned deferred prosecution agreements. Those of you in North America will be very familiar with this. We had this tool introduced into the UK last year, and there hasn't been one yet, but I'm going to just jump onto that in a second, because Barclays may well be the first case. But there's been a new approach. There was a speech by Ben Morgan a couple of months ago about the new SFO approach, which was basically urging self-reporting. And everyone urges self-reporting, and there's a bit of carrot and stick. You'll see there that if the SFO detect the problem, if you detect a problem, you've got to self-report early, fully, honestly. All of those things will be familiar with you all. Those are the threats, the prosecution of people who are less than frank, again, a threat. And the new opportunity is this deferred prosecution agreement. And the idea that you can do a deal has caused a bit of furore in the UK, because a lot of groups, Transparency International, say, oh, it'll all be cosy deals. But the first invitations by the SFO for a DPA went out in May, and interestingly, today, the press, on the front page of the FT, the Barclays deny that they've been made an offer, and they talk about discussions at a very, very early stage. But given that the chairman of Barclays, John McFarlane, has said publicly that he wants to draw a line under the conduct issues that have plagued the bank, getting the errors of the past behind us, it would seem that a DPA might be a sensible way to go forward. But Larry was saying people are beginning to focus on the financial institutions. With Barclays, the SFO who opened the criminal investigation some years ago had the temerity, some people thought, to bring in very senior executives, managing directors and others, to be interviewed what we call under the Police and Criminal Evidence Act. In other words, criminal interviews as you would a suspect. Now, the SFO also uses what are called Section 2 interviews for witnesses, but they brought in very senior bankers and interviewed them as if suspects, which caused quite a stir, and obviously that is what has been leading to these discussions about a settlement. But one of the things that I understand is a sticking point in these discussions, and it is a point that is key going forward at the SFO, is whether certain evidence, that's advice from the bank's in-house and external lawyers on the deal, is covered by legal privilege. Now, the SFO wants people not to trample the crime scene. You see the reference there. And they're wanting the primacy of the investigators to be the SFO investigators. What they don't want are banks and others using their external lawyers, interviewing witnesses, and then claiming privilege for the interviews with the witnesses. The SFO say, we want to get at the facts, we should have the primacy of investigation, and you external lawyers must stand back. Now this obviously is a dramatic new approach, and it is one that's causing some consternation, both with the companies and lawyers, because the company needs to know the depth of the hole. It needs to know, is it really in a problem, and what sort of problem? And if it just has to rely on the SFO doing an investigation at its own speed, then that may conflict with the duties it owes to its shareholders to get on and resolve matters. So that is going to be a problem going forward. So DPAs are now in. The SFO says it's no longer why DPA, but how DPA. In other words, people are going to be very keen to use them. I think that's going to be right, but much will depend on the first one. There hasn't been one. It's going to be a brave entity that goes in for the first DPA. I also understand from my US colleagues that DPAs are in fact falling out of favour rather than being in favour. So that's an interesting contrast. So the SFO is saying, don't make any false claims to privilege. External lawyers, we don't want you investigating. We want to get access to the facts, and we'll only give you a DPA if you fully cooperate. And that has been quoted in the press as meaning including waiving privilege. I'm not sure that's a fair quotation in the press. I think that's an issue which will be debated heavily going forward, because the SFO says it wants to challenge incorrect claims to privilege. But the short point is banks, financial institutions are definitely going to be in the firing line. This is a live example and will be unfolding over the next weeks and will give us something of a roadmap going forward. So the director of the SFO, who is keen to show the SFO as a success, is fighting one hand the Home Secretary, who wants to abolish him. He's fighting financially because his budget's been cut by 34%, and he needs to deliver a DPA in a major case, and he needs to launch a successful prosecution under Section 7. And if he does all of that, I suspect his contract will be renewed in April, but it's a tall order. Thanks, and with that, I'm going to hand over to John Hickin in Hong Kong.
Thank you very much, Alistair. For my segment of the presentation, I wanted to draw out a few themes which we see emerging and of increasing relevance in the Asia-Pacific region, although with a particular focus on China. To start with, and to provide some context, anti-bribery issues have very much come into focus in Asia, given the rapid emergence and growth of economies across the region in recent years, and also the fairly dramatic increase in foreign investment into the region. And we've seen fairly rapid expansion also of enforcement activities and efforts from both within the Asia region and also from outside, as Larry and Alistair have already mentioned. And in particular, in the China context, we are very much in the midst of an ongoing crackdown on bribery by the Chinese authority. And I think perhaps people have heard of the what's being described as the Tigers and Flies initiative by President Xi in China. The message really being that no one is too big or too small to be pursued. So it's against that background that I want to consider a number of themes that we see emerging in this part of the world and in these markets. So turning to the first of these themes, challenges from entering new markets in Asia. Many parts of the region have fairly protectionist legislation for local banks and financial institutions. So foreign banks, financial institutions are often forced to enter into partnerships, joint ventures, or other forms of collaboration in order to get access to those markets. And that need to access markets indirectly through agents, joint venture partners, or other forms of collaboration often mean that banks are exposed to the risk that the agents and so on they deal with either have already or are perhaps more prone than otherwise to engage in bribery or other corrupt type practices. And invariably, these agents and affiliates tend to be linked to the state, often state-owned enterprises, especially given the extent to which state organs reach into and control business in economies like China, Vietnam, and elsewhere across the region. So as a consequence of that, foreign banks looking to access Asian markets often face heightened risks in relation to FCPA and other anti-corruption laws. In addition, another point to note and to deal with is that often multiple approvals are required to set up presence in many of the markets in Asia. And this means increased risks. For example, when one looks at China, there are no less than 13 different levels of agency one has to navigate before you can secure a banking license. So of course this increases the prospect of having to deal with government officials and obviously the FCPA risks that those contacts present. Next slide, please. Now, what I would like to look at in this slide is to turn to some of the different types of relationship that a bank may become involved in when entering markets in Asia, which will require the bank to work closely with local players. Oftentimes, banks and financial services companies will seek to enter new markets through joint ventures. And in this regard, it's worth noting that a bank can be liable for FCPA sanctions based upon the actions of employees of agents of the joint venture, noting, as Larry mentioned earlier, some of the circumstances in which the FCA allows liability to arise without direct knowledge of an improper payment or a bribe. Also, when entering markets in emerging countries, it's also common for banks and financial institutions to rely upon third-party agents to act as local intermediaries. However, it's important to remember it's not obviously permissible to use those third-party agents simply as a way of circumventing the provisions of the FCPA or the Bribery Act. And of course, you may well find yourself liable for the acts of a third-party agent if it's found you are willfully blind or you failed to initiate adequate safeguards against those types of corrupt acts that the agents participate in. When dealing with agents in particular, it's also important to look for certain red flags at the pre-hiring stage. So, for example, a third-party consultant which you're considering engaging, which you're considering on the basis of relationships, perhaps as opposed to their particular industry expertise, that would be a cause perhaps for concern. I've also already mentioned the prevalence of SOEs, but also PEPs have become a significant issue in the markets across Asia, and a means for large financial institutions sometimes to gain favor and business from local government agencies. Now, this is a topic that I think is emerging of quite significant importance, so I'll come back to this a little bit more deliberately in a few minutes. And finally, for this slide, obviously to the extent that you are acquiring a company to gain market entry, and that is an option in a particular market in Asia, and it is in certain markets, although not all, then of course you need to be aware of assuming the predecessor company's liability, including in relation to FCPA violations. And obviously, target companies in these new markets in Asia quite often have poor compliance programs for anti-corruption. And because of that, the past or ongoing conduct may cause you as a purchaser or investor to be held liable for those past lapses. Next slide, please. Given these risk factors, it's obviously important to conduct thorough risk-based FCPA and anti-corruption due diligence when you're looking at potential new business partners in the Asian jurisdictions. And the scope of that due diligence inquiry should be tailored based upon not just the company you're partnering with, but also the country in which they operate. In particular, the scope of a due diligence inquiry could take into account various factors. So, for example, what we find in reporting by Transparency International's Corruption Perception Index regarding the particular country where you're looking to invest, other red flags that might suggest that there's a heightened risk. It's also important to try to secure representations, contractual certifications, and other sorts of compliance commitments in the transaction documents that you enter into, perhaps in the joint venture agreements that you might enter into with those partners. And you also need to work out a compliance plan once you've done the deal, as it were. So a number of steps can help you ensure that the venture going forward won't run into difficulties. So, for example, taking steps to ensure that a code of conduct that governs your activities extends to the new business or the new formed merged or partnership entity, to ensure that sufficient and proper training is available. Also, I think it's important to post-investment make sure that there's a country-specific FCPA audit taking place as quickly as possible. And I think the other point to bear in mind is that if problems do emerge and are identified, then obviously, with the benefit of advice, it's important to consider whether it's appropriate to make any disclosure in relation to those sorts of problems. Next slide, please. The final point I wanted to make in relation to my first theme is that just really to stress the diversity of approach to corruption-related issues across the different Asian jurisdictions. Now, I've referred to already China, and I'll make further references to China throughout this presentation, but need to be cognizant of the fact that the position in China may be very different to that which you find in Malaysia, in Indonesia, in Thailand, and there can be on some occasions, dramatic differences, on others, more subtle differences. So it's important to appropriately tailor your compliance to the local circumstances and to understand those local circumstances. And what I try to illustrate from this slide is just one example of that in respect of the position on gifts. So obviously an affirmative defense to the FCPA is where payment or a gift to an official is held lawful under the written laws and regulation of the official's host country. And what you can see from the table is that various de minimis exceptions for giving gifts to officials in various localities vary, the first point, and secondly, they are much lower given the lower standards of living in those places than they may be in US or Europe. So just something to be alive to. Next slide, please. Turning now to my next theme, this is the increasingly vexed and complex question of how to deal with requests for disclosure in the context of FCPA investigations in particular in relation to conduct which takes place in Asian jurisdictions. The SEC and DOJ in their investigative efforts often require disclosure of documents or information from overseas. And this often gives rise to conflicts with both foreign blocking statutes and we're finding increasingly also data protection legislation. Again, using China as an example, China has a very widely drafted state secrets law, and this prevents disclosure of any documents containing what are described as state secrets without proper authorization from government. And I extract some language here from the relevant statutes, and you can see from that, especially the second limb of it, which covers other matters that are classified as state secrets by the administration, that in practice this can be pretty wide-ranging and frankly can cover just about anything. Next slide, please. So the other point to note is that there are fairly severe sanctions for violating these state secret and other data privacy type legislative provisions in China and other jurisdictions in Asia, including in the case of state secrets in particular, potentially terms of imprisonment. But obviously on the flip side, there's also the risk that failure to disclose may result in sanction from the US regulators. So businesses finding themselves subject to these sorts of investigations may find themselves as a catch-22, and the prospect of exposure to possible sanctions from the regulators in the host jurisdiction in Asia, but also from the investigative agency perhaps in the US. Next slide, please. So what can you do to protect yourself? Well, in 2013, China announced a new procedure for disclosure of sensitive documents to foreign regulators. And as you can see from the slide, this involves certain processes involving screening, redaction, certification, and also governmental approval. But without any further specific guidance on this, it's difficult to work out, for example, when faced with questions about state secrets, exactly how to deal with these issues. So our advice generally is that the prudent approach would be to seek further, more specific guidance from the authorities, and also to take legal advice from international counsel and to do that early. And I mentioned that it's important to involve international counsel because what we found in our experience is that trying to secure the certification from a local firm in China, for example, isn't necessarily very straightforward, and that advice will tend to be very heavily caveated. Next slide, please. So notwithstanding the China procedures that I've spoken of or given an example of, and also various mutual legal assistance treaties, MLATs, which the US has entered with various other Asia countries, this area is still very complex. And I think basically when you're faced with these issues, there is no substitute for doing some level at least of in-country review of the documentation and the materials in question, and also to think very carefully before transferring any documents, even electronically, out of the jurisdiction. And if in any doubt, certainly seek advice on those issues and before taking any such step. So country-specific advice, very important, and obviously it varies in some cases significantly from one jurisdiction to another across Asia. Next slide, please. The third and final theme that I wanted to talk about that's become increasingly topical in Asia corruption investigations in recent times relates to enforcement efforts in relation to financial institutions which have offered employment or internship opportunities to the offspring of senior officials. Now, this issue is particularly acute where the princelings, that is the description that's been commonly adopted for these types of hires, don't possess satisfactory or appropriate qualifications or experience for the positions in question. So it's important, I think, for institutions to be conscious of their exposure to and associations with PEPs, and also obviously their children and relatives. And as we've seen with recent efforts by the Chinese authorities in particular in past months, there really is no safe haven for these sorts of investigations. No one seems to be exempt from the enforcement efforts of the Chinese authorities. So notwithstanding someone's association with even a very high-ranking official, it seems that everyone is fair game in the current environment. Next slide, please. So finally, I just wanted to highlight some examples of cases that fall into the Princeling category as it's described. I'm conscious that I'm trespassing slightly into the time of the next presenter, so I will leave you with that slide to read and not speak to it. So that concludes the first part of the presentation this morning. Next slide, please.
Thank you, John. While the SEC enforces an array of securities laws against a wide variety of market participants, in this section we are going to focus on SEC enforcement priorities and tactics against investment advisors. And over the last several years, the SEC has increasingly focused its enforcement attention on these advisors. In 2010, the Enforcement Division created within it the Asset Management Unit, which was tasked with investigating and prosecuting violations of the securities laws by investment advisors and investment companies and private funds that they manage. In addition, OCIE has increased its expertise in the investment advisor industry, particularly investment advisors to private funds, by hiring both more and more experienced examiners. And OCIE, as many of you already know, is the section within the SEC tasked with conducting examinations of registrants, including investment advisors and broker-dealers, and OCIE is the Office of Compliance Inspections and Examinations. Whereas OCIE used to routinely conduct sweep exams and what it characterized as routine examinations, it is increasingly relying on risk analytics, data obtained by the agency to conduct more targeted examinations designed to select advisors for examination based on a perceived likelihood of finding violations. And in addition, the SEC's whistleblower program, which was created in 2011, is now maturing and is turning into a significant source of leads for the Enforcement Division. All of this makes for an increasingly dangerous regulatory environment for investment advisors. And unfortunately for investment advisors to private equity funds, the SEC has recently focused its attention in their direction. Last May, the then current director of OCIE, Andrew Bowden, gave a speech entitled Spreading Sunshine in Private Equity, in which he summarized the results of OCIE examinations for over 150 private equity fund advisors. And he reported that OCIE found violations of law or material weaknesses in controls in approximately 50% of the private equity private equity exams that it conducted, and most of those were in the area of the manner in which advisors charged fees to the funds they advised and also allocated expenses, both between the advisor and the fund, and also the allocation of expenses among portfolio companies within a fund. And the examples he gave were things like private equity fund advisors presenting operating partners and consultants to investors as if they were part of the advisor's own team, implying that the management fee paid by the fund to the advisor would cover the services of those consultants and operating partners, when in fact it did not, and the funds were charged separately for the work of those consultants, all done without what the SEC perceived as adequate disclosure to investors. Another example he gave was advisors billing funds for back office functions, things that were traditionally included in management fees like compliance, legal, accounting work, but in these cases charging separately for those services, again, all without adequate disclosure to investors. So in light of these findings and the prevalence of those findings, it's no surprise that the SEC's Enforcement Division has sharpened its focus on private equity funds. And since that speech, the SEC has provided additional information on the status of its examinations and findings on private equity funds, and Rich will speak to that.
And Matt, one of the things that you were mentioning is that Bowdoin came out with a speech in 2014, and it was a little bit seismic for the industry. Everyone took that as a new day for OCIE. A new day for the shop that was always viewed as the folks who came in and did reviews of the industry, but didn't necessarily either set itself up or believe it was, or in fact actually hold itself out as an arm of the Enforcement Division. When Bowdoin came out, and among other things, one of the things we love to talk about at a variety of speeches that we give is everything you need to know about the Enforcement Division of the SEC and the SEC is right on the SEC's website. I'm in many ways an old-timer. I was there in the 90s, and back then the website used to say the investor's advocate, and that was how they billed themselves as the SEC. Today, I believe there's a quote, is it Mary Jo White? Is that right?
It's a quote on the Enforcement Division
webpage that says, "We are first and foremost a law enforcement agency," and that difference of public face is everything you need to know about the Enforcement Division, and a lot of what many people thought and still think Bowdoin was signaling as to how OCIE was going to conduct itself going forward. Matt and I, in a private conversation with a client and OCIE, had an OCIE official say, I think inadvertently, but say anyway out loud, there are no longer periodic reviews. Everything now is a targeted or serious review. And that, again, will tell you what they're thinking. Mark Wyatt came out with a speech in May of 2015 that many people, I think including Matt and I, view a little bit as a bit of a walking back of OCIE, although I don't know that you can ever walk back from the position that was staked out. But it definitely talks in terms of the President's Exam initiative that was started in 2012, where OCIE and its new thinking wanted to set itself out as the folks who were going to go out and make sure that everyone knew they were there, knew what they were doing, and ensure that the industry understood who they were, particularly the investment advisor industry, has now stated that they're done with the President's Exam. They did more than 150 of them. They said that it took over 25% of the industry into account, and they feel like that was a good place to be. And that signals a bit of, okay, we're going to go back to some potentially, so we don't know, but potentially some more routine examinations coming back, as we'll talk about a bit in the future, sort of recidivism, coming back at folks that they've seen before that they may want to see again. And also they signaled again, and why it took the time to sort of reiterate parts of Bowdoin's speech and emphasize certain points. So not to take too long, but some of the main points that he identified seemed to come from the cases that have been brought over the last couple of years. And we'll talk a little bit more in detail in just a minute about those cases, but the main areas that Matt just went through are expenses and expense allocation, shifting expenses away from one fund to a parallel fund, maybe if there's co-investors, potentially if they're insider co-investors, you'll see this in a lot of cases, shifting expenses away from those folks to their benefit to the main fund. Broken deal expenses shifting away. We'll talk about the KKR case, which is really what Wyatt's referring to there. And then co-investment allocation, as I just said, there was a comment by Wyatt that really sums it all up that says all investors deserve to know where they stand in the co-investment priority stack. As an old-timer, I've always thought of this as side letters. Different investors get potentially different deals with the fund, and they're not saying that that's not allowed. They're saying that everyone deserves to know what everyone else is doing, and that is a bit of a shift that you need to understand. He also talked in a bit of detail about real estate advisors because they felt that they were more vertically integrated and therefore they needed to disclose fees and expenses because there could be fees and expenses charged back to funds that are perfectly acceptable but just need to be disclosed, such as employees providing asset management services, in-house attorneys being paid, and one thing that they really wanted to get clear was real estate managers often promise rates at or below market rate for any of these services, and so the SEC made a point to say, how are you determining what market rate is, and to benchmark. So Wyatt has gone out and staked some territory out that's a little bit outside of Bowdoin, showing what I think not only are some of the priorities, but some of what the SEC is going to be most, Enforcement Division is going to be most active on in the next couple of years. So one thing you need to know, and sorry, I'm working slides and talking, so I for a long time, I've only been able to do one thing at a time. Not a multitasker. So one thing you need to know about in this area, and this isn't, I'm going to steal a bit of what Larry said. This isn't a seminar on rolling through the different Advisor Act potential charges or claims, but we need to give you a little grounding to make sure you understand where we're coming from. And the SEC has really focused its cases, which we're going to talk in detail on in the next couple of slides, on not surprising areas, but areas that Bowdoin and Wyatt both made sure that they highlighted. Misrepresentations, obviously anything that's an actual intentional or unintentional misrepresentation of how a fee, an expense, or anything else is being charged, benchmark, whatever it may be. Don't forget failure to disclose in that area. It's not just an actual inadvertent or intentional misrepresentation or even an unintentional misrepresentation. It's also failure to disclose, and that's going to be a big part of these cases, particularly one area that is undisclosed conflicts of interest, particularly when you're handling one or more funds or managing more than a set and expenses are shared. And then, of course, they'll often tack on or even potentially bring its own case on compliance failures. So something to keep in mind with policies and procedures, even if you had them, did they fail or did you not have them at all? These are all issues you're going to want to make sure you are considering. These are things you hear in most seminars and you're aware of these things. Again, same thing with what are the violations. So I'm going to do that relatively quickly. Essentially, we're talking about Section 206. And what I'm going to give you for today, although we could do a whole seminar on Section 206 alone, for today, all you really need to know is 206.1 and then 206.2 and 4. 206.1 is essentially intentional. Intentional action, it is willful or reckless. If something rises to the level of recklessness, that is a 206.1 violation. A negligence, potentially even a mistaken issue, a mistaken misrepresentation, a mistaken failure to disclose. And we'll talk about the Lincolnshire case where they brought 2 and 4, and it seems like although they had policies, they from time to time didn't seem to follow them. You know, some things that one party may look at as inadvertent, and the other party, being the SEC, so they get a lot of say in this area, may look at as not necessarily willful, but they should have done a little better than that. And it's worth mentioning 20647 very quickly, which is just ensuring that you have adequate policies and procedures, that you do an annual review, and all the other things you hear about in the compliance standpoint.
And one of the sources of increased regulatory risk to advisors is that OCIE seems to be working more closely with the Enforcement Division than ever before. Although OCIE, which conducts examinations of registrants, has always had the ability to refer potential violations to the Enforcement Division found during the course of exams, it is now seems to be actively coordinating its activities with the Enforcement Division. And this is not just with respect to investment advisors to private equity funds, but applies across the board to all investment advisors. Now, to be sure, OCIE's annual exam priorities for this year include the fee and expense issues charged by private equity fund advisors that we discussed earlier, but also a range of other issues that apply more generally to investment advisors, things like products and services offered by advisors to retail investors, especially products previously considered to be alternative investments or investments for institutional investors, to make sure that those investments are appropriate and suitable for retail investors. They're also focused on investment advisors that the SEC considers to be recidivists or advisors that were found to have deficiencies in prior OCIE examinations. In addition, OCIE has generally strengthened its ability to detect potential violations in the course of examinations. And I referred to this a moment ago, the use of data analytics and perceived risk factors to select entities for examination. It uses computer models to identify those advisors based on a variety of perceived risk factors that include things like unexplained fluctuations in assets under management, the departure of senior officers, including chief compliance officers and CFOs, changes in auditors, and reported investment performance that is unusually high or smooth in relation to advisors of peer funds. And OCIE has also created a private fund unit to focus on examinations of investment advisors to private funds, including private equity funds. And I think one factor that illustrates the increasingly close coordination between OCIE and enforcement is the fact that it's selected for head of this new private fund unit within OCIE. It selected a former member of the Enforcement Division's asset management unit to lead up that group.
So I want to make sure we get into the whistleblower sections, and I'm cognizant that we're getting close to the end of time. So I'm going to categorize all of the cases that you see in front of you on slide 27 sort of as how they're viewed, and we've already talked about intentional and inadvertent. There are both of those here, and I'll talk a bit more about them. And then also in categories of sort of what's happening. KKR, for example, which I mentioned earlier, is misallocating or unfairly charging fees or expenses to investors. In this case, it was about $338 million of broken deal expenses, and that it didn't disclose in any form that they were going to allocate broken deal expenses to co-investors. So the real part was the concept of unfairly requiring funds to shoulder the cost for nearly all expenses incurred without telling them or telling investors that that was going to happen. And that there was also, they added in, no written policy to govern expense allocations. And that was something that, as Matt just mentioned, the co-chief of the SEC's asset management unit highlighted seriously. Taking a look at clean energy, and the reason that that's an important case to talk about very quickly, is that came from an OCIE exam, and that's a perfect example. They thanked at the end of the press release by the SEC. It's obviously a close coordination between OCIE and the Enforcement Division, and in this case, it was a willful fraud. So in this case, there was a misallocation of funds, about $3 million. In many cases, they really did go after and fleece the funds for their own benefit, including rent, salary, tuition costs, retirement. One of my favorites, and I'm sorry, I'm a little jaded because I was the prosecutor and now I'm on even the defense side, was that they used 70% of the funds money to pay their own bonuses at the end of the year. And this is just so we're clear, in addition to millions of dollars that they were taking in management fees, not just as management fees. Obviously, the FCC frowned on that and will often frown on fairly significant frowning on willful fraud. So it's worth taking a really brief overview on Lincolnshire. Just to say that the FCC said that it was a from time to time issue of not following on some occasions its policy. And this is in the FCC's own press release and case, right? So this isn't that they didn't have a policy. This isn't willful violations. This is that they did not follow their expense allocation policy on some occasions. That's a direct quote. That's one thing to leave you with, right? That is not the strongest language I've ever heard in either a charging document or a press release, but it does show that they are quite serious in wanting to police this area and taking very seriously what this area will mean. So I think we're going to keep moving on for now.
And one I think important takeaway from some of those cases that Rich described is that in this environment, it's very important for investment advisors to clearly disclose in initial offering documents and then on an ongoing basis its arrangements for charging fees and its arrangements for allocating expenses, both between the advisor and the fund, and then also within or among portfolio companies within a particular fund, and then to follow that up by making sure that they do what the documents say they're going to do with respect to fees and expenses.
And I know we're bleeding just a little bit over the hour, but it's worth mentioning the BlackRock case, which came out in April of this year, in which they were talking very seriously about having disclosure to clients, ensuring that your disclosure is adequate, not simply putting disclosure into an ADV Part 2, which is a big deal because that was the initial reaction of almost everyone in the industry. Let's get all our disclosures out in the ADV Part 2, and then we'll be good. And the SEC is taking a position that may be enough, that may not be enough. You have to ensure at certain times, if there's a material compliance matter like there was in BlackRock, that you go and inform the board and potentially make a client disclosure as well. So they're staking out some really interesting territory where disclosures are there, but not necessarily in a form they think everyone has seen, recognized, or necessarily truly hits the issue at hand. It's going to be an interesting time going forward. But the more disclosure, as Matt just said, that you feel you can have is often the better.
And two remaining issues I want to discuss briefly, although they could probably be the subject of separate webinars in themselves. First is what's referred to as the Compliance Program Initiative, but is sometimes sometimes sort of thought of more of as a recidivism initiative, and it illustrates the close cooperation between OCIE and enforcement. And essentially, it was described by the co-chief of the Asset Management Unit in a recent speech, which is referenced on slide 28. As an initiative targeting firms that have previously been warned by SEC examiners about compliance deficiencies but then failed to act upon those warnings, or firms that have wide-ranging compliance failures. And there's two cases that I've included on the slide in the matter of trust and investment advisors and in the matter of Transamerica Financial Advisors. In both of those, there was one and sometimes several OCIE examinations that identified deficiencies. The investment advisors were advised to fix those deficiencies, and sometimes they related to compliance deficiencies or in another reporting of performance, or providing performance reporting to investors, and the advisors failed to adequately heed the direction of OCIE. And in both of these cases, OCIE came back 2 to 3 years later and found that the deficiencies had either not been fixed or hadn't been adequately fixed, and at that point, the matter was referred to enforcement. So the takeaway for these is that if OCIE identifies deficiencies during an examination, you want to fix them and make sure that you address them comprehensively throughout the organization, not just in a particular branch office where the deficiency may have been found, because there's a reasonably good chance that within 2 or 3 years, OCIE staff is going to come back, do a follow-up examination, and see what you've done, and if you haven't adequately addressed it, you may be facing an enforcement action.
I want to just jump in, Matt, and hit that really strongly on the head. Matt and I are starting to see right now OCIE return exams. They are coming back to folks where they had a deficiency letter or a comment letter previously, and that the comment or deficiencies had, whatever it may be, 8 parts, 3 parts. And the first thing we see them asking is about those 3 parts, let's say, again. So not only do you need to fix those areas, documentation, having policies and procedures in place, those are what we like to call your story. That's your first answer. Sorry, we like to call it the answer, right? When they come and say, show us what you've done as to, and that'll be the question that OCIE asks, show us what you've done as to these deficiencies we identified previously, you want to be able to hand them the policy, and then they'll probably dig into whether or not that's being followed, as we saw in Lincolnshire. From time to time, the policy wasn't being followed, but that's your first answer to the SEC. And if you don't have that, then you've got an issue of beginning to try to explain what you did to correct the issues from last time, and that's a place you don't want to be.
And then lastly, I think I'd like to speak briefly about the SEC whistleblower program, which began in 2011 and the SEC has devoted significant resources to that program, and it's become a significant source of leads to the agency. And we've seen in the last couple of years SEC awards to whistleblowers, which they've publicized, and there have been, since 2011, 14 separate awards to whistleblowers, most of them coming in the last year or two as whistleblower tips have come in. Usually there's a lag time of several years before enforcement action is brought, and the awards to whistleblowers can be significant in matters of which result in over $1 million in sanctions being recovered by the SEC. Whistleblowers can obtain awards of between 10 and 30% of that amount, with the largest award to date being $30 million to a whistleblower. And in addition to the whistleblower program being a source of referrals to the SEC, it's also created the potential for additional violations for investment advisors in 2 areas in particular. The first is the whistleblower provisions preclude or prohibit retaliation against whistleblowers, and the SEC last summer brought its first retaliation case against an investment advisor who had a portfolio manager who reported a potential violation to the SEC. And the whistleblower wasn't terminated, but saw a reduction in the authority he had at the workplace. He was moved from portfolio manager to a compliance position. He lost supervisory authority. He was tasked with investigating the allegations he had brought, and his work environment was significantly diminished. And that was significant. That was significant enough for the SEC to bring a whistleblower retaliation claim under the Exchange Act. And more recently, the SEC brought a case which is described on slide 30 in the following slides in some detail in the matter of KBR. And that case was brought in April of this year, where the SEC determined that a broad confidentiality statement that employees were required to sign when they were interviewed as part of an internal examination violated an SEC rule that prohibits doing anything to impede a whistleblower from communicating with the SEC. And in that case, KBR was conducting an internal investigation as part of a key TAM complaint that had been filed against the company, and used a statement when interviewing employees as part of that internal investigation. It was a statement they had been using for many years that had a broad confidentiality requirement, and employees were required to sign it. The statement is provided on slide 30, but in essence it prohibited employees from discussing any particulars regarding the interview and the subject matter discussed in the interview without prior authorization of the law department, and then threatened disciplinary action up to and including termination in the event that they violated that. And that statement and the language in that statement was reported to the SEC and the Department of Justice. It came to light during depositions in the underlying QI-TAM civil litigation, and the SEC brought an enforcement action, and KBR was agreed as part of the settlement to amend its confidentiality statement to include a carve-out, which is described on slide 31, saying in essence that nothing in the statement prohibits the employee from reporting possible violations of federal law to any government agency or entity, and then includes a variety of agencies, all of which were, I suspect, involved in the underlying QI-TAM case, the Department of Justice, the SEC, Congress, and any agency inspector general, or making any other disclosures protected under the whistleblower provisions of federal law. And I think this is an important case because investment advisors, when entering into agreements with this kind of with a broad confidentiality provision, whether it's severance or termination agreements with employees, it could even be instructions as part of a document hold notice, or resolving disputes with customers or clients or investors, need to be cognizant of the KBR case and make sure that the breadth of a confidentiality provision isn't so broad that it could result in a violation of SEC whistleblower rules. And with that, I'd like to turn the presentation back over to John.
Thank you very much. Thank you again to all of the participants for joining us. We hope you found the webinar of use and of interest. As mentioned before, if you submit a question that hasn't been answered, we'll follow up with you in due course. If you have any other questions about today's topics, you can email them to Erica Weber at eweber@mayorbrown.com, and we'll answer your questions as promptly as we're able to. Thank you again for your participation today. Goodbye.